All right, let's talk about one of the most maddening parts of any family court case. What do you do when your co-parent just seems to disappear whenever legal papers show up? Today, we're not about getting angry, we're about getting smart. This is the playbook to keep your case from getting stuck in limbo, so let's get right into it.
Does this sound a little too familiar? You're ready to sort out custody, get support figured out, but you can't even get out of the starting gate. Why? Because your co-parent is dodging the process server, not picking up certified mail, and basically using avoidance to bring the whole process to a dead stop. It's frustrating, and you are definitely not alone.
So here's the deal. The law has this first essential step called service of process. It's really just the formal prove-it-to-the-court way of showing the other person got the paperwork. But that requirement can totally be used as a weapon. Really simple things, like literally just not answering the door, can become a huge delay tactic for things that are critical for your kid.
So, let's give this a name. We're going to call it the vanishing parent problem. And look, this isn't some kind of spy thriller with secret hideouts. It's actually a whole bunch of really boring, everyday actions that, when you put them all together, create a massive roadblock in the legal system.
And if you look at these tactics, what's wild is just how normal they are. It's not answering the door when you can see the lights are on. It's that certified letter coming back stamped refused. It's their mom or their best friend always saying, "Oh, they're not here right now." The craziest one? They might be texting you about the kids, but when it comes to getting served, ghosted. Recognizing this isn't just you going crazy, it's a pattern, that's the first step.
Okay, listen up, because this right here, this is the most important mindset shift in this whole explainer. To get past this, you have to completely change your objective. This is no longer about trying to win an argument or prove they're a terrible person. It's about something way smarter, way more strategic.
And that's it. This is the core idea. Let that one sink in for a second. Your job isn't to confront them or to call them out. Your job is to calmly, professionally, and methodically build a record of every single one of your good faith efforts. This one change in perspective is what breaks the logjam and puts you back in the driver's seat.
And this chart just lays it all out, plain and simple. The column on the left, procedure, proof, due diligence, that's the language the court speaks. They reward you for coloring inside the lines. Now look at the right side. Anger, emotional arguments, claiming they're hiding. Even if it's 100% true, to a judge, that's just noise. Your frustration is valid, but it is not evidence.
So, how do you build this record you keep hearing about? You create something we're going to call a proof packet. Think of it like a professional, organized binder of facts that does all the talking for you. It's going to become your single most powerful tool to prove to the court that you did everything by the book.
This is the heart and soul of your packet. A simple, boring, factual log of every attempt to serve. But notice the details here. Date, time, location, and the most important part, objective observations. Car in driveway, dog barking inside. This isn't your diary where you vent your feelings. It's a business-like log that shows a clear pattern of you trying to do the right thing.
Now, besides that log, your packet needs a few other things to be rock solid. You need proof of why you think they're at that address. You know, a screenshot of a public record, an old utility bill. You need proof they even know a case is happening, maybe a text where you mention it. And the gold standard? A formal, sworn statement. An affidavit from a professional process server. A judge takes that very seriously.
Okay, you've got the right mindset. You're starting to put your proof packet together. Now it's time to talk about execution. Let's put this whole strategy into motion.
Here's a pro tip. If you hire a process server, which is often a really good idea, don't just give them the address and say, "Good luck." Treat them like your strategic partner. Give them a photo. Tell them what car your ex drives, what their work schedule might be. You're not just paying someone to knock on a door. You're directing an operation to build your record.
And this is absolutely crucial. Not all attempts are created equal in the court's eyes. Trying to serve someone 3 times on a Tuesday at noon, to a judge, that can look kind of lazy. But this, trying at different times of day, on different days of the week, an early morning, an evening, a weekend attempt, this matrix is how you prove you made a real, diligent effort.
So, once your packet clearly shows a pattern of them avoiding you, it's time to climb the legal ladder. Step 1, you've documented everything. Step 2, you file a formal request, a motion, with the court asking for permission to serve them a different way. Now, Step 3 is key. You ask the judge to set a specific date when service will be officially complete. That stops them from ever saying, "I didn't get it." Once the judge signs off on that, you're finally moving again.
So after all this work, what does winning actually look like? Well, I can tell you,
It's probably not the big, dramatic courtroom showdown you see in the movies. It's something much quieter, much more procedural, and honestly, a lot more effective.
The big prize at the end of this whole playbook is getting an order for what's called alternative service. All that means is the judge looks at your proof packet and says, "Yup, you've tried hard enough. You now have my permission to officially serve them just by mailing the papers or even taping them to their last known front door." That court order is the key that unlocks your case.
So see, the real win isn't some gotcha moment. The real win is the ink drying on that judge's signature. It's knowing that your case can't be stalled anymore. It's being able to move forward for your child's sake. And maybe best of all, it's having a court record that shows you were the calm, reasonable, and diligent one the whole time.
And remember, all through this, let your record do the heavy lifting. The language you use in your logs and your court filings matters. So instead of writing, "They're hiding from me," you write, "Respondent could not be served despite due diligence." See the difference? One's an emotional accusation. The other is a legal fact backed up by all your hard work. Look, at the end of the day, a situation like this can make you feel completely powerless. But by shifting your focus from winning an argument to just building a solid record, you take that power back. The evidence you gather is undeniable. Your record is your power. And now you have the plan to build it.